there is a specific provision of the New South Wales Stamps Act which requires that where a change of trustee is occurring, in order to ensure that no stamp duty is payable on that change of trustee, the new beneficiary needs to be excluded as a beneficiary of the trust. There needs to be an express exclusion on that new trustee stepping in. Now, if we're practicing in New South Wales, we're probably acutely aware of that, and we're acutely aware of the impact that that has when we're appointing new beneficiaries and when we're looking at who may have been a previous beneficiary, a previous trustee who may be excluded. For those of us who are outside New South Wales, that's not something that's necessarily at the front of our mind, but it has two significant impacts if one of our trust deeds contains this provision and we're not aware of it. And this comes up quite commonly because certainly several of the quite popular online deed providers, as well as a number of the national law firms, use trust deeds which are based on New South Wales drafting, even though it might be ordered by an accountant in Western Australia or it might be recycled by a lawyer in South Australia. If it's a New South Wales originally drafted trust deed, this provision will more than likely be in there regardless of where our client's based. The importance of that and the importance of identifying is twofold. Firstly, if we have a change of trustee and we've appointed a new trustee who was a beneficiary of the trust, then that change of trustee may be invalid, and we may have a whole range of tax and stamp duty issues around anything that that new trustee has purported to do since they were appointed. So there can be a lot of commercial issues there. The second one is that we may have people who were previously a trustee of the trust who at face value appear to be a beneficiary of the trust, but are inadvertently excluded as a result of this exclusion provision. So if mum and dad were individual trustees, but they subsequently retired and appointed a corporate trustee, even though they may be named as beneficiaries of the trust, they may have been excluded as a result of that provision. That has an impact from a family law perspective. It also has an impact from a tax perspective if we've been purporting to make distributions to those individuals, thinking they were beneficiaries, not being aware of this exclusion hidden within the back of the deed.